Yes, good morning, Ms. Mkhwanazi.
Good morning, Chairperson.
Good morning, Mr. Nciza.
Good morning, Chair. Thank you.
Thank you, Chairperson. Mr. Nciza, please confirm that you are still in possession of the 2 files we've been using over the course of the past few days.
Yes, I am.
Thank you. When we closed yesterday, we were on page 24 of your witness bundle. 24, please.
I'm there.
Thank you. And we were just about to commence with a new topic, highlighted in bold on page 24. Can I ask you to read that into the record? I'm not sure I'm brave enough to attempt that, please.
Thank you, ma'am. On 20 August 2023.
Can I ask that you start with the heading? Please read the heading.
Oh, yeah, sorry. The heading is Beakley, Anonymous Emails.
I'm indebted. Can I ask you to detail for the Commission the events you set out at paragraph 74?
Okay, should I read them or just?
Please, in your own words, yes.
Okay. Commissioners, on the morning of the 21st of August, I woke up and I saw on my emails on my phone, that was an email that had come through on the evening of the 20th August 2023, which came from a rather funny email address, which was beakley852@yahoo.com, but it also had a name stamp of beakley.me. The email was sent to Jeff Wicks at News 24 with Mr. Shega, Dr. Mashazi, Deputy Commissioner Spies, Chief Mapieye, Advocate Bihari, and myself copied. The email had a subject line that read favoritism, corruption. And it had as an attachment the charge sheet that I read yesterday for Brigadier Mkhwanazi. It read, "Hi Jeff, I'm reporting on the basis of anonymity. Some time ago, you reported a very serious incident to one of our colleagues about one security firm called Cat VIP. The incident took place some time ago, earlier on during the year. My understanding is that a certain law firm was appointed to oversee the matter by charging Julius Mkhwanazi. According to a document in my possession, Julius Mkhwanazi was charged and his hearing was supposed to sit sometime in July this year. However, this did not happen. And as such, Julius Mkhwanazi has since not faced a disciplinary hearing. I suspect that the law firm that was appointed could have received something in return. Please report this to the media and shame the municipality for protecting corrupt officials. Please be careful, however, because Julius is highly connected with Madlanga, who is also a suspect in the murder of Decoran Babita, together with the CFO. My case of unfair labor practice has also not been solved by the municipality or by Egoruledi. Please follow up on this as we need people like you to clamp down on corruption. I'm told from reliable sources that Imogen Mashazi, who's the city manager, is the one who's protecting Julius Mkhwanazi.
Thank you. The email you've referred to is annexed there as PN12 at paragraph 77 of your witness statement. Could you then carry on and set out for the Commission the events subsequent to you receiving that email?
Yes. Commissioners, I read this in the morning and I called Chief Mapieye because he was also copied on the email. She indicated to me that he has not seen the email. I think he was on his way to drop off somebody at school. It was early morning. He had not seen the email as yet. And I did not respond or not have an opportunity to properly consider the email. because I was a witness on that day. I was a witness in a labor dispute that involved an unfair dismissal case against the municipality. So I went to my arbitration where I was a witness, and indeed we commenced and we proceeded. During a break in the proceedings, where the legal teams were busy with engagements on some documents that the commissioner had directed them to clarify, I noticed that I had a missed call from Ms. Kasheka, and as I was checking my phone, saw that there was a missed call, and then she called again. And I indicated to the commissioner that I need to take this call. It's from my supervisor, and the commissioner allowed me to take the call. When I stepped out to engage with Ms. Kasheka on the call, she instructed that I must come to Germiston. I was in Benoni where the hearing was held. I need to come to Germiston, and I need to come to Germiston with immediate effect. Indicated that I am a witness in an arbitration and I can't just up and go. You know, she said, doesn't matter. You need to be here, and you need to be here now. Okay, where here exactly? You need to be at the city manager's office. I said, okay, fine, let me see what I can do. I engaged the legal rep of the municipality to say that it seems there is an emergency, therefore I need to rush to Germiston. Fortunately, the commissioner is a well-versed person who has been part of the bargaining council panel of commissioners for a while, and he understood my role in the municipality. He then allowed that I should depart the arbitration proceedings. We were almost at the conclusion of the evidence in chief, so I could depart, and if I'm able to, I should indicate whether I'll be able to come back and finalize my evidence in chief on that Monday. This was a Monday. I then left. On my way, I got a call from the attorney that had been appointed to prosecute in the matter of Julius Mkhwanazi. And he indicated to me, hey, there's a problem. He had just received a call from Advocate Kemi Behari instructing him to drop whatever he's doing and to come to Germiston. And he reflected that, but firstly, I'm not an employee of the municipality. I cannot just be instructed to drop everything I do. I've got other clients. And as a matter of fact, he's outside of the Gauteng province, busy with another matter for another client. And I was like, but what did he say is the problem? You know, because I've also been instructed to come to Germiston. He indicated that the problem that Advocate Behari told him is an emergency, is this issue of the Beatley email. And that Advocate Behari has accused them as the attorneys of leaking Julius Mkhwanazi's charge sheet. And was like, but this is absurd. You know, we do our work, we're professionals. We've submitted the charge sheet to the municipality. You know, that is our work, and we've requested the municipality to facilitate the serving of the charge sheet. So you can't come back to us and say there's a leak, and therefore the leak has been done by us as the attorneys. You know, I was like, hey, you know what? I have been called. Let me go and hear what is happening. But he confirmed that indeed he was confronted by Advocate Behari regarding the leakage or leak of the charge sheet. I went to the city manager's office, and upon arrival, I did not find Mr. Kasheka, and I was told by the personal assistant that I should wait. There's a waiting area. I should wait. She'll contact Mr. Kasheka. I was like, but the person phoned me and said that she's here. I'm still busy in another process. So what's happening? Said, hey, DH, I don't know what's happening. I advised that you simply wait. I waited for what seemed like about 45 minutes before indeed Mr. Kasheka arrived. And when she arrived, she was with Advocate Behari. And then I was ushered into the boardroom of the city manager. At the boardroom of the city manager came in as well, had some documents on her hands. We sat, I think I sat next to Advocate Behari. Mr. Shega was opposite, the city manager was at the head of the table. It's a conference table. And it was like, yeah, what is this thing of this beetle? Like, okay, what beetle? What are you talking about, Sam? Yeah, no. You know, you have leaked the charge sheet of Julius to the media. I have leaked the charge sheet of Julius. Where does that come from? No, the charge sheet was given to your office. Yes, all charge sheets are given to my office. You know. Came tell him. And Came was like, yes, we called the attorney. The attorney said they emailed the charge sheet to you. And I said, yes, of course they emailed their charge sheet to me. All charge sheets get emailed to me. So there's nothing new. But now the charge sheet is found in the Beetle email. But that doesn't mean that it was me. Because as much as it was emailed to me, I was not the only recipient of that email. The email had other people as well, people from the department who had worked on the matter. Even my manager, the final charge sheet was also emailed to my manager, was going to facilitate the serving of the charge sheet.
When you say that email, are you referring to the email from the attorneys? No. Which email?
The email from the attorneys. So, thank you, Commissioner. Not the Beetle email. The email from the attorneys on the 20th of June. You know, the final draft of the charge sheet. So I indicated that, but this email was sent not only to myself, not only to my manager in my office, but it was also sent to the colleagues in the department that the attorneys were working with in the crafting of the charges. You know, so there's a multiplicity of people that would have had access to the charge sheet. No, but that's wrong. Dr. Mkhwanazi charged that. No, but that's wrong. You can't have that. I'm like, but that is how it's done. The department is the one that must make the case. They are the ones that must be also comfortable.
What was she saying was wrong?
What she said, it was wrong that the charge sheet could have been sent to other people.
Okay. Right.
You know, she argued that no, but that's wrong. You know, how can you have such a thing? I'm like, no. City manager, you must understand. As much as my office must facilitate the serving of the charges, but the people that must make the case in a disciplinary hearing is the department, not my office. The people that are going to witness, the people that are going to talk to the evidence is the department. So the department works closely with the prosecutor in the crafting of the charges, because the prosecutor is going to require them to be witnesses in the matter. So they need to have sight of what exactly are the charges so that they can be in a position to comfort themselves that indeed we can speak to these issues. Because it won't make sense. You know, you go, you draft a charge sheet, your witnesses can't talk to the charges. You know, is that so? She then confirms it with Advocate Behari, who also confirmed that, yeah, it is correct that indeed we need to engage with the department. So then the allegation now, the accusation, let me not say the allegation, the accusation changes to say, if it is not you, then it's somebody in your office who has leaked this. If it's not somebody in your office, then it's somebody in the department that has leaked this. So I get instructed that I must provide Advocate Behari with the emails that were shared by the attorneys so that they will conduct an investigation on this leak. So no, it's fine. I mean, emails are emails. I'll send them through to Advocate Behari.
By that, do you mean email addresses to which
the actual email?
The attorneys, the actual. Okay. Let me finish what I was saying. By emails, do you mean the email addresses to which the attorney's email was addressed?
What was required of me was to, because they needed to see the email thread, you know, in terms of who would have been emailed. They wanted to see the actual email. So I was to then forward the email thread so that they can be able to ascertain who exactly would have had sight of the chat sheet. You know. So I agreed. I said, no problem, I will do that. I'll just get back to the office and I will attend to that. You know. Then Advocate Behari explained something that was a bit off for me. You know, now you must understand, DH, we like calling people by titles, Commissioner. So when we're in a room, there are HODs, CM, and a DH. So you must understand, DH, that, you know, this is a very serious matter. Like, okay, what is the serious matter, Advocate? Says, no, what is serious is the fact that Mkhwanazi's personal details on the charge sheet. And therefore, this thing of the charge sheet been given to Jeff Weeks, who is an external party to the municipality, is a violation of his rights in terms of the Poppy Act. Okay? And therefore, I'm like, okay, I understand that, but there are issues that are also raised.
And what were the personal details on the charge sheet?
The personal details on the charge sheet.
To assist you, Mr. Nciza,
yes.
The charge sheet is annexure PN10. It starts on page 292 of your annexure bundle, 292.
When you look at page 292, and this is the funny part, Commissioners, it's the disciplinary hearing with the case number between the City of Ekurhuleni Municipality and Julius Mkhwanazi, employee number IGE 0120. Those are the only details on the charge sheet. This can be contrasted with the details that will be on on a suspension letter. The details in a suspension letter are more, you know, than this. We have all sorts of things in a suspension letter, including ID numbers and the likes. But in a charge sheet, we don't put what would be termed personal details, because an employee number is an institution detail more than anything else. But this was the allegation that was put to me to say, you know, this thing has got personal information of Mr. Mkhwanazi, and therefore the municipality is running the risk of a OP Act allegation or claim against it.
Based on your HR experience, and you have vast experience indeed, would this employee number be of any possible use or significance to people outside of the municipality? I'm trying to understand why Advocate Behari would have been concerned about such information.
At the very most, not at the very least, at the very most, what we would do with a pay number is when an employee, for instance, applies for a loan, you know, then they want information about your employer and your employment details, so that when a bank or any other service provider wants to verify your employment, then they can then use both your employee number with the employer, as well as your other details like your ID numbers and the likes. You know, but ordinarily when they do a verification exercise, it's not just the pay number that is used to verify that indeed this is the employee that you're talking about. because pay numbers, especially in an institution as big as Xolani, get used all over the place. We use pay numbers in all sorts of documents. So it's easy for a person to pick up another person's pay number.
Well, thank you. I hope you still remember where you were. Please continue.
Sorry, Mr.
I'm saying I hope you still remember where you were. Please continue.
Mr. Nciza, you were at paragraph 84 of your witness statement.
Yeah, in the situation in that meeting, quite honestly, was hostile. I was under attack, and I had to push back. I had to push back to say, but even this issue of the personal detail, my understanding is that there is no significant personal detail that is on a charge sheet, that would really compromise the institution. And also, I had to push back on these allegations of leaks. I defended my office. I said, you know what? I know my office has dealt with thousands of charge sheets over the years. And we've dealt with quite high-profile matters where even you had tender irregularities that would be brought, contraventions of the MFMA, serious contraventions of the Municipal Finance Management Act that we have had to deal with as the office. So for me, it didn't make sense that there would be a leak from my office on a matter of this nature. So they then took a view, the city manager now changed the issue to now raise questions about my authority to appoint lawyers and legal representatives. And I answered to say, but this has been the authority of the Director of Labor Relations since the commencement of the municipality in 2000. It's more than 2 decades that we've had this situation in the municipality. No. But Julius is a senior employee. He's a senior person. You can't be disciplining him. You can't discipline Julius. But I've disciplined people that are senior than Julius. I've disciplined people that are on a senior position, a senior rank than Julius, both in the EMPD and in the institution. No. This is wrong. This is wrong. Why do we even have authority to appoint attorneys? But I've got authorities given by your office. And that authority has been there even for my predecessors. They've always had authority to appoint lawyers in matters concerning labor litigation as well as internal disciplinary proceedings. This has happened with many cases.
Did she suggest who, if not you, should discipline Brigadier Mkhwanazi?
She did not suggest who should discipline Brigadier Mkhwanazi, but what she did was to say this must change. To which Mr. Shega then responded to say, yes, we're in the process of changing it. I had to pose the question, is it changing because of this matter? All sorts of other matters have been handled throughout the history of the municipality, and there was never a need to change something that has been with the employee relations unit.
In terms of the hierarchy, where you have touched on this, but just in this context and to remind myself, where would you place yourself in relation to the city manager? How many places down would you be? I just want to get an idea who then would be better placed according to the city manager to discipline Brigadier Mkhwanazi.
In a hierarchical arrangement, if the city manager was number 1, then the HOD would be number 2 or be number 3. That's how the structure is in the municipality. You'll have the city manager, you've got HODs, then you've got divisional heads.
Meaning somebody like Brigadier Mkhwanazi would then have to be disciplined either by the HODs or the city manager herself, according to what the city manager was saying.
According to what she was saying in that meeting, which does not align to the delegations matrix that is informed by, like I indicated earlier on, that you've got effectively 3 dispensations on discipline management that were applicable in the municipality. You've got the city manager and HODs disciplined in terms of the disciplinary regulations. The divisional heads are disciplined in terms of Schedule 8 of the Labor Relations Act. And then you've got everybody below the divisional heads who were now part of the bargaining unit. Mkhwanazi was part of the bargaining unit. The authority of the divisional head employee relations in terms of discipline management applies both to Schedule 8 discipline processes as well as the bargaining unit. So as the divisional head employee relations, the only people that I was not authorized to appoint a disciplinary tribunal for is HODs and the city manager. But everybody else in the institution, I was authorized to appoint a disciplinary tribunal for. And I, not only myself, my predecessors, there's precedents all over the place that points to the divisional head having the authority, and it has always been exercised by the divisional head. At no point was there an issue, at no point whatsoever in the history of the municipality until in the meeting of the 21st of August, 2023.
And in fact, I think there was something wrong in the language used by the city manager, because on my understanding, but you'll correct me, it is not as if, for example, in the case of Brigadier Mkhwanazi, you were disciplining him as such. You were packaging the documents that would then be used in the disciplinary process. Am I correct? Yes.
You're correct, Chair. You're correct, Chair.
And on my understanding, again, when it came to who would sit or chair a disciplinary hearing, if it was internal, you said it would be someone 2 places senior to the person being disciplined. And then, if not done internally, then a tribunal would be appointed and outside people would then get involved. So you are not disciplining as such someone senior to the person being disciplined. If, for example, Brigadier Mkhwanazi's matter was to be heard internally, it would not be heard by you. You would not chair the process. But someone, did you say 2 places? Someone above, whatever the levels, someone above Brigadier Mkhwanazi would have had to chair. You want to comment?
You are very much correct. You are very much correct. In this instance, the provisions of clause 7.6 of the disciplinary procedure collective agreement would apply because that will be the default position where now I'm appointing an internal. In the instance of Brigadier Mkhwanazi, the only post designations in the municipality that would have been able to chair and effectively discipline would have been senior executive managers who are on C18, would have been divisional heads, who are also above C17 because he was on C17, divisional heads, or else an HOD. All of these would have then been senior to him, and in effect, in terms of the disciplinary code, would have had the authority to then sit and preside over his matter and discipline him. We are quite spot on in that particular respect. Outside of that, then it would be an external legal practitioner who then would not fall within the rank system of the municipality. The hierarchical system of the municipality, it's a legal professional who is competent to then exercise the function of discipline.
And did you get to know the nature of what Mr. Sheka said they were putting together?
Oh, yes.
In order to amend what was in existence, so that you should not discipline someone like Brigadier Mkhwanazi?
Yes, we got to know. We got to know the very next day. We got to know the very next day. I mean,
Yes, very briefly, can you state what this innovation was?
It's in the papers. It's in my statement.
Oh, okay. You're still coming there?
Yeah.
Yes.
Okay, let's leave it.
Thank you, Chairperson.
On this topic that you're discussing with the chairperson, Ms. Nciza, at paragraph 89, this is where you explain your responses to the city manager in that meeting. And then it is the second part of that paragraph 89 that I think you should explain to us what exactly you were referring to when you say I had done cases that the city manager had instructed action. Can you just explain a bit more there?
I can explain this by way of example, without mentioning names of people. In the Economic Development Department, there was a divisional head who had misconducted themselves. I don't want to use the gender so that, misconducted themselves. And then the head of department, in line with a directive that I mentioned yesterday, that the city manager had issued in 2017, this head of department then did a motivation to institute an investigation. That motivation was taken via my office to the city manager, because the city manager had said you can't investigate a divisional head without her approving that. Then we submitted that motivation asking for an investigation to be conducted. The city manager approved the conducting of that particular investigation. The investigation was conducted. After the investigation was conducted, another report was submitted to the city manager to say, here is the findings. We are now asking permission to discipline. And the city manager was like, sure, proceed. I then appointed the disciplinary committee. So that's what I mean by it's effectively any instruction that firstly proceed with the investigation and proceed with the disciplinary proceedings. It was not an HOD that signed or appointed. I appointed the attorneys with full knowledge of the city manager. And this is a position that is higher than the Julius Mkhwanazi position.
And the city manager did not have any issues with the fact that you've appointed attorneys. You've exercised the power to appoint attorneys.
Madam Commissioner, like I said yesterday, this came out of the blue, even with regards to the discipline of heads of departments. And during the tenure of Dr. Mkhwanazi as the city manager in Ekurhuleni, we've had about 5 instances where we had to discipline heads of departments. And in all those instances, as much as the appointment letters were signed by her, they would be crafted by me. Because it's in my space. I would be the one that then crafts the appointment letter with even inquiries, would be myself, indicating that for this particular matter that has been approved by council, where council has now mandated the city manager to institute disciplinary proceedings, we are appointing this firm as prosecutors. So my role has always been very intricate in all discipline management processes. And that is the only instance where I would then draft the letter for her signature. But all others, I draft the letter, or my office drafts the letter for my signature. I appoint attorneys.
Thank you, Mr. Nciza.
Thank you, Commissioner. Mr. Nciza, before we continue with the subsequent events of that day, could I just ask you to turn back to paragraph 85? You're on page 27. And you set out some reflections in paragraph 85. Can I ask you to share those with the Commission?
Thank you. Yes, Commissioners. I want to stress to the Commission that by virtue of my role in the city of Ekurhuleni, where I am responsible for discipline management, and any body commissioners that has been in a labor-intensive environment would understand and appreciate that discipline management is a very tricky, sensitive function. You know, you get exposed to all sorts of things as a person who is regarded as umqashi. You know, you are regarded and even colloquially called umqashi as the head of labor relations.
You want to translate umqashi.
Employer, the employer. You know, people have that tendency. And remember, indeed, you become the employer because even though you don't chair the disciplinary hearing, you are the one that implements the outcome. A chairperson of a disciplinary hearing will make a finding of guilt and then issue a sanction of dismissal. You, as the divisional head employee relations, are the one that must sign the dismissal letter. It is employee relations that will then issue the termination to the employee that you've been found guilty in this case. Attached is the sanction from the presiding officer. Your services are terminated. You know, so you're always going to find yourself in the firing line. You know, you're going to find yourself in the firing line. I have, over the years, like I indicated yesterday, that even before I assumed the function of divisional head in 2017, I had acted and I was always involved, you know, in discipline management from a very early stage of my management career. So I was always in the firing line. I've had a lot of defamatory claims and allegations made against my person, you know, on social media. There's been instances where my name would be the subject of even engagements in trade union meetings. You know, I've been threatened with harm and insults, and I've never received, save for something that I will engage on later on, save for an incident that happened in 2011, which was a very unique dispensation that occurred in the municipality that changed even our labor relations and dispensation in the municipality in 2011. But I've never received any intervention from the employer. I've never sought, let me be upfront, I've never sought intervention. I've never gone and cried foul to the employer to say, hey, you know what, these unions, these employees are threatening my life. You know, I've never cried foul. These are risks that I understood and accepted as being part of my job. You know, if you are going to be in a labor relations environment, you are going to be bruised here and there. But in all of that, I was shaken by the emerging pattern of interference that emerged with specific regard to this matter. I had said yesterday, I have served under not about 5 city managers. Dr. Mkhwanazi would have been the 5th city manager of the city of Ekurhuleni. None of them has ever interfered with labor relations functions. None. Dr. Mkhwanazi herself, in a first term of office, she served 5 years from 2016 December until around about 2021 November. You know, she had never interfered. But very serious matters, inclusive of even matters that involve HODs, would constitute, she would sign the appointments of the attorneys. I would work with the attorneys or advocates in crafting charge sheets against HODs. I would facilitate the serving of those charge sheets, and I would facilitate the disciplinary hearings of those HODs. Senior people to me, but my office would facilitate because that's our role as labor relations, you know. And I've never received any form of interference whatsoever from the office of the city manager. city manager's role was to say, how far are we? Give me a briefing. What's going on? Are there challenges? If there are challenges, I would escalate them to her. Not even to the HOD HR, directly to her.
So her interference in Brigadier Mkhwanazi's matter, disciplinary matter, was the first and last.
It was the first.
And last.
Well,
No, to your knowledge, or whilst you and her were involved within the municipality.
remember, we are now on the 21st of August. 2 weeks thereafter, I get suspended. So what if indeed there is any other further interference? I'm no longer in the picture to deal with that.
All right, thank you.
Thank you,
But-
Chair.
For the first time, I experienced the situation wherein senior management, and I'm going to articulate this further and more succinctly when I deal with what I would call the cover-up. Senior management, for the first time, was hell-bent on protecting an employee, regardless of procedures of the municipality and processes of the municipality. Senior management acted as if they are shop stewards of this employee.
Thank you. Mr. Nciza, you were taking the commission through the complaint about your power to appoint external lawyers. You can pick the conversation up again at paragraph 90 on page 28.
Before you do that, Mr. Nciza, at paragraph 86, you say this is where you record Mr. Sheka's reply that we are correcting that CM, and this is about your power to brief external attorneys. Now, before this meeting and before Mr. Sheka said this in the meeting, had she raised with you ever the issue about your powers to appoint attorneys, one, and then two, that she's doing something about it to change that?
Nope.
This was the first time you heard that she is working on correcting that, whatever she meant with it.
There had never been a discussion, Commissioner. There had never been a discussion. The only discussions about attorneys that I would have with Mr. Sheka was money issues. We were honestly owing attorneys left, right, and center. Attorneys and advocates. It was just a problem with regards to the budget. So that is the key discussion that we were having those days. Since she became the HOD, there was always an issue about payment of attorneys.
So
As a result, in our discussions, because of the payment issue, there was a sense that we need to scale down on appointment of attorneys, because we don't have funds. We are owing money, and therefore, if we continue to appoint, we're simply ballooning the expense. That was the only discussion. It was not about my authority to appoint.
So just to be clear, and at this meeting, this is the first time you became aware that the city manager and Mr. Sheka have some problems or issues with your power to appoint attorneys. This was the first time you heard anything about it.
It was the first time.
Thank you. Thank you, Ms. Mutase.
Thank you, Commissioner. Paragraph 90, please, Mr. Nciza.
Yeah, commissioners, as I have said, I tried to push back and I indicated my issues about my experience in the municipality and the delegations matrix and the likes. But Dr. Mkhwanazi maintained a complaint that I could not appoint attorneys for a senior employee. My understanding of her attack was that it's Mkhwanazi is some senior employee. So effectively, I do not have the right to discipline senior employees. You know, I took a different view. Yes, he's senior, but he's not senior than me. But also, I've been involved in discipline of people that are senior than him. But I realized that, you know, this is going nowhere. I was talking to people that have made up their mind. They've made up their mind, you know, and it didn't matter what procedural arrangements have been in place. They had made up their mind, and therefore it was not going to assist me to argue the matter any further. Yeah.
Please proceed.
Oh, yeah, there is something I don't think actually it's appearing, Council. During the course of this discussion, there is something I'm not sure where it is in the statement, but during the course of the discussion, the issue of the service of the charges did come up.
Please proceed, Ms. Nciza.
Thank you. The issue of the service of the charges did come up, where indeed Dr. Mashazi had raised an issue to the effect that, but you know, this thing, even though you did not even charge Mkhwanazi. She raised something to the effect that you don't even charge Mkhwanazi. I indicated but we had received the charge sheet. Lasheka instructed my office not to serve the charge sheet. I actually told her that Lasheka instructed my manager not to serve the charge sheet, you know. And Mashazi was like, okay. He was like, okay. Yeah. And it was simply left at that. But yeah, she instructed not to serve the charge sheet, it's fine. You know, Advocate Behari had also indicated that, but not he had I'd looked at the docket. No. You know, the evidentiary material, that's how we call it. The evidentiary material is not sufficient to sustain a dismissible of misconduct.
As at the time when you left, Ms. Nciza, did you ever come to know whether an investigation was conducted by Advocate Behari to arrive at his conclusion, and whether any written report about that investigation and the conclusion which Mr. Behari conveys in the meeting, whether there was ever a report about it?
Yes and no, Madam Commissioner. There is no investigation in relation to the substance of the allegations against Brigadier Mkhwanazi. No investigation was ever conducted to determine whether there is merit to the allegations. Remember, we have the Erasmus report. At that point, the only report that existed was the Erasmus report, and the Erasmus report says there is basis for a case to be instituted. Advocate Behari, I came to learn via Chief Mapieya that indeed on the 21st of June, there was that engagement with Chief Mapieya. He went through and you can see the investigation report is 276 pages or so. Went through the report and took a view that there is no basis to proceed. You know, beyond that, there is nothing. Firstly, the so-called no basis to proceed, there is no communication in writing from Advocate Behari to Chief Mapieya, let alone myself as the person who took the decision, you know, but there is nothing that was actually issued by the legal department that says we've reviewed the contents of the docket or the investigation report. We found that there are certain gaps, and these gaps are such that they would result in this being a fruitless exercise, not even a fruitless expenditure, but a fruitless exercise, because these are not dismissible for 1, 2, 3, 4 reasons. The allegations are not supported by evidence. We don't have that. And we do not even have an instance where there was an investigation commissioned on top of the Erasmus report that then looked at the merit of the evidence. We don't have that. The yes, that was the no. The yes is that indeed there is some report called the forensic report. And I think at some point in my statement, I will deal with that. But it is not a report that talks to the substance. It's a report that talks to the handling of the disciplinary hearing. It doesn't talk to the substance of the allegations.
I know you're still coming to it, and we've had sight of it. That report doesn't, as I recall, express any view about the merits of or the strength of the charges against Brigadier Mkhwanazi. Am I correct in my recollection of that report?
You are very correct, Madam Commissioner. It doesn't even attempt to.
Yes.
That report was about something else. It had nothing to do with whether Brigadier Mkhwanazi needs to answer for his conduct.
Yes.
No.
Right. Now, you may have dealt with this yesterday, and forgive me if you have, and I'm making you repeat it. Had Advocate Behari in particular, but also the department in general, the legal department, have they previously, before this, had any role in reviewing disciplinary charges or cases against employees at the level of Brigadier Mkhwanazi, whatever position he was holding at the time?
Madam,
and I'm speaking to your internal processes. I'm not speaking to where you are now at the bargaining council or in the labor court.
Madam Commissioner, the Labor Relations Unit in Ekurhuleni is a fully fledged unit that has a divisional head, 2 senior managers, 1 for compliance and collective bargaining, another senior manager for case management and litigation. It has 6 senior specialists. So the management component alone is 9 people. And that unit functions in terms of all processes that are labor relations related. The legal department, in terms of the structural arrangements of the municipality, would play a role where there is litigation at labor court level. Even then, it's a support role. It's a support role. The Labor Relations Unit in Ekurhuleni since around about 2006 has been capable and indeed has been entrusted with the responsibility of dealing with labor litigation matters from end to end. There's an organizational management principle that talks to end-to-end accountability, which would mean that you are able to account for the start of the function up to the end of the function. The responsibility resides with you. So even my performance contract, detailed that. My delegations detailed that. So would require assistance from the legal department where indeed there is a matter of some intricate nature that requires their attention. But ordinarily, we're fine. Until, of course, Mr. Advocate Behari became the HOD. Then things started changing. Started off with a matter that involved a head of department. I think it was the head of department, and then there was another matter that involved before even he became the HOD. There was another matter that involved, I can't mention, unfortunately, the designation, because there's only been one person in that designation. So if I mention it, it will be obvious to the world that I'm talking about that case. But there was a matter that involved a very senior person at HOD level, where then the city manager took a view, Dr. Mkhwanazi took a view that I'm close to that person and therefore I should not be involved. And Advocate Behari should play the role that I normally play. Outside of that, he has never been involved. He has never been involved. There has never been a review of a disciplinary process by the legal department. There has never been a need for that. You know, all disciplinary processes were handled within the labor relations unit.
Thank you. Thank you, Ms. Mkhwanazi.
You said, Mr. Nciza, Advocate Behari said, after his review of the evidentiary material, it did not reveal that there was a dismissible offense. To my mind, that implies that there could well have been an offense, but one that was not dismissible. Did you understand him to mean that, or did he mean there was no offense at all? I hope you get the nuance.
I get the nuance, Chair. I get the nuance. Indeed. The way that it was, he put it, he spoke to a dismissible offense. You know, he says that the evidentiary material does not point to a dismissible offense. My engagements with Chief Mapie, he had indicated to Chief Mapie that the 300,000 rand donation and the lack of procedural compliance with how that donation was sourced could, at best, result in a slap in the wrist. Now, I've checked the disciplinary code. I do not find a sanction called slap in the wrist. You know, so, but nonetheless, to him, these were minor. You know, these were minor. To me, as a person that has dealt with discipline management, I know for a fact that we've dismissed employees for less infractions. You know, there are less infractions that you would find that an employee gets dismissed for. An employee gets dismissed for an infraction, dismiss the cashier there's a concept that we learned at some point called cash rollover, where we dismiss the cashier for cash rollover of 500 rands. You know, you dismiss because that was 500 rands that was supposed to be banked by the municipality, but was not banked, you know, by this cashier. So we dismiss for that, you know. So, but then we get told that all sorts of things that were done are not dismissible. And I was like, yeah.
Thank you.
Thank you, Chair. Mr. Nciza, you've relayed to the Commission that in the course of that meeting, Dr. Mkhwanazi brought up the issue of the lack of service of the charge sheet on Brigadier. Now, your evidence during the course of yesterday was that the HR manager from your office who was tasked with delivering that charge sheet informed you that Brigadier Mkhwanazi refused to accept delivery on the basis that both the city manager and Mr. Xolani advised him not to do so. So in the course of your engagement with the city manager, did you put that allegation to her? Did you open up a conversation with her about her role in blocking the service of the charge sheet?
No, I didn't raise her role. I raised Mr. Xolani's role. And she was like, no, it's okay. You know, I didn't say you instructed. I said Mr. Xolani instructed that the thing must not be served.
And
honestly,
nothing.
I didn't attack her on it.
And nothing further than came from her concerning any potential part she played in blocking that service.
When I raised the issue of Xolani, you know, sometimes you raise an issue thinking that at least it will ignite a response. You know, Xolani just simply said, yeah, and then she was like, okay, no, it's fine, and moved on and changed the subject from a discussion on the charge sheet to a discussion on my powers. You know, so honestly, there was no further engagement beyond that.
On the subject of your powers, the next material date is the 22nd of August, 2023. Can I invite you then to paragraph 93 of your witness statement? 93.
Yeah. Thank you, Counsel. This is now informed by the instruction that I had received that I must send to Advocate Behari the emails and the email thread so that he can be able to investigate this issue of the leak. So on the 22nd, I indeed sent the emails to Advocate Behari. Now, later on in the day, I was contacted by one of my employee relations officers who sent me a WhatsApp. And I think I was just driving out of Benoni on my way home. And then I stopped the car and I got into a garage and I opened the WhatsApp. And I saw the document. The document was a document that was signed by Dr. Mkhwanazi and listed Ms. Xolani as the inquiries person. Now, commissioners, the protocol in the municipality is that as much as there is a person who signs the document, the person that is listed as inquiries is the person who drafted the document. So the insistence that the city manager always has is that if you're going to draft a document for her, you must be the inquiries person so that nobody must ask her about the document. You know, this was introduced by Dr. Mkhwanazi to say, no, if you're going to require me to sign, list yourself as the inquiries person so that people must not come to me, they must go to you as the drafter of the document. So, indeed, I opened the message and the attachment, and I found the document on PN 13.
Let me assist you. PN 13 on page 311. And Mr. Nciza, perhaps before we go into the text of PN 13, just in the course of your evidence this morning, take the commissioners through paragraphs 94 and 5, and then we'll turn to the statement just for completion.
Okay. So I went through the letter that is on PN 13. Having gone through the letter, I contacted Ms. Xolani via WhatsApp, noting that, of course, the inquiries person, as reflected on page 311, is Linda Xolani. So I contacted her. I texted her a message to the effect, "Good evening. I just wanted to check the authenticity of this document." And the document is this one, PN 13. The purpose of my message was to check with her if indeed this document was genuine. At about 20:50, 10 to 9 in the evening that day, Ms. Xolani responded, "What does OCM say?" OCM is the Office of the City Manager.
Thank you, Mr. Nciza. I'll then invite you to turn to page 311, which is annexure PN 13 itself. And perhaps before you pass comment on its contents, please confirm that this is the document you received via WhatsApp on the 22nd?
Yes, it is.
That's right. And just read into the record what the subject of the document is in bold.
The subject, the document is dated the 23rd of August. It's addressed to all departments and all employees. It's from Dr. M.I. Mashazi. The subject is disciplinary and...
You said 23rd, am I mistaken?
22nd.
22nd, yeah.
22nd August. The subject is disciplinary and grievance procedure in the city of Ekurhuleni, authorized representatives of the city manager.
Thank you. And the paragraph immediately under the heading in bold, could you just read that first paragraph starting the South African Local Government Council?
The South African Local Government, it's supposed to be Bargaining Council, the B is missing, SLGPC, concluded a disciplinary procedure collective agreement, DPCA, on the 1st of February 2018.
And that is the document we took the commission through yesterday.
Yesterday, yes.
Right. And so please then explain to the commission the context of this guideline or document you received vis-a-vis the DPCA that we went through yesterday.
Like I indicated, commissioners, that how we have structured the delegations matrix in respect of the DPCA in the municipality, you would not have a authorized representative. You would have authorized representatives of the city manager. Hence, even the heading of this document refers to authorized representatives of the city manager in terms of the DPCA. So this document then is a document that talks to the issues that are on, is it 15B?
Thank you.
Yes. So when you look at the issues that are in 15B, this document effectively is a modification of 15B.
Thank you. Mr. Nciza, then if you turn to page 312.
Yes.
Under the two bullets, there's a paragraph that reads the above listed functions. So to place it in context, it's discussing the handling of disciplinary proceedings. Correct. So there's a paragraph there that reads the above listed functions required. Do you see that paragraph?
Yes.
Thank you. Could you read that paragraph, please?
The above listed functions required specific authorization from the municipality/city manager to be given to the various layers of management to ensure that disciplinary processes are handled in an expeditious and equitable manner. The collective agreement, however, does not specify who must handle some functions it provides for. For example, in the municipality, who in the municipality appoints the chairperson of an appeal hearing, or who agrees on an appointment of panelists of the SLGBC to hear the appeal if the employee makes such a request, etc.
Please also read the next paragraph.
To usher in expeditious, credible, consistent, and uniform management of discipline within the municipality, the following persons are herewith delegated to perform the above listed functions, as well as all other functions connected therewith as appears from the collective agreement in that regard, as the municipals/city manager's authorized representative.
And so when you read those paragraphs together, the city manager is saying that the aim of this document is to provide for the management of discipline within the municipality by identifying specific persons who must exercise delegated functions. Is that correct?
Yes.
All right. So, Mr. Nciza, I'll then take you through each of the subparagraphs at the bottom of that page, but I'll invite you to read the heading and to pass a comment in respect of the amendment as it lies there, or the change as it lies there. So paragraph A1 reads, receiving allegations of misconduct, and under the bullet point, it says HOD of a respective department. Now, please advise the Commission whether that is a change or a retention of the existing procedure.
It's a retention.
Thank you. Immediately beneath that is paragraph A2, which says request for allegations to be investigated must be submitted to HOD Corporate Legal Services. Please confirm that that is the position held by Advocate Kemi Bihari.
Yes.
Thank you. So the allegations then must be submitted to HOD Corporate Legal Services upon determination of a prima facie cause for the HOD Corporate Legal Services to confirm the allegations, consider the evidentiary material, and then submit a report to HOD HR. Please again confirm for the Commission whether that is a modification from the previous document or whether it retains the existing position.
That is a serious modification.
Please elucidate your point for the Commission.
I don't know, Council, whether I should take them through what my response was to this, because my response is very detailed. I don't know how do we want us to.
Let's then, I'll take you to your point in your response where you deal with paragraph A2.
Yes.
Does your response, Mr. Nciza, refer to the numbering, like the A1, A2, B, C, and
Exactly.
so on? Or if it does that, I think he may do that, Ms. Mkhwanazi.
Thank you, Chairperson.
Thank you.
Mr. Nciza, then I will ask you to turn to page 316. That is annexure PN 15.
Yes, ma'am.
Thank you. Just to locate this in your witness statement, this is a document where you say in paragraph 97, you describe it as a comprehensive response to the changes in the document What's Up to You. Do you confirm that?
Yes, ma'am.
Thank you. And then you say the purpose of that document is to set out why the revisions are unlawful, inappropriate, and against the best interests of the city.
Yes,
Do you
ma'am.
confirm that? Thank you. When you have regard to page 316, can I ask you again to identify the author of the document?
It's myself,
You directed the document to,
the city manager.
and then please tell the Commission, read for the Commission the heading in bold on the first page.
The heading is Disciplinary and Grievance Procedure in the City of Ekurhuleni, authorized representatives of the city manager.
Okay. I'm going to follow the format adopted with respect to the guideline issued by the city manager, which is that I will read the proposed, the new guideline, and I will then ask you to respond to it. So we have already addressed paragraph A1. I have already read for you paragraph A2 into the record. Can I then ask you to comment for the Commission on what you described as the serious revisions to paragraph A2?
Thank you, Council. Commissioners, on page 317, I detailed, it's from 317 to 318. I submitted to the city manager a detailed analysis of the implications of A2. I don't know, can I just read them?
Chairperson,
Yes, Ms.
my proposal, I'm in your hands, but my proposal is that in light of how lengthy it is, it might be a time-consuming exercise.
I also wanted to suggest that perhaps if you could just deal with the salient or set out the salient points that you made.
Thank you, Commissioner, Chairperson. The first issue that I raised with A2 is the requirement for the request for allegations of misconduct to be investigated to be submitted to the HODLS, CLS. In the municipality, I had indicated this in my testimony before, Commissioners. The municipality has got various investigations units. You know, we have the monitoring and evaluation investigations unit, which investigates infractions that would happen on the e-notice system, where you have people that have registered cars or even licenses in an inappropriate manner. So those people investigate, and they've got a legal obligation to do that investigation in terms of the Road Traffic Management Act and whatever acts that they use. You have that. You've got the Integrity and Standards Unit of Internal Affairs, the Erasmus unit. You've got loss control of, again, EMPD that also deals with this. You've got the Internal Audit Department that also conducts investigations. And then you've got MPAC, the Municipal Public Accounts Committee, that also would institute investigations. Now, MPAC is even more serious because this is chaired by a councillor, and councillors are part of the committee. And that committee has got a legal obligation and powers to actually institute investigations. Now, A2 says you can't have an investigation unless it's approved by the HODCLS. You know, it's just impossible. You know, effectively, you are saying that councillors cannot investigate. They must get the authorization of their junior, because all of us are juniors to councillors. That's the political leadership of the municipality. But also all these other units that have got vested investigation authority. Now that authority is taken away. They must, before they can conduct any investigation, they must get approval from the HODCLS. It's just impossible.
And sorry to intervene, Mr. Nciza. Then on the facts as they've been relayed to the Commission today, how would that change affect the sequence of events we are informed of? So, for example, we understand that the allegations of misconduct against Brigadier Mkhwanazi were brought to the attention of Commissioner Spies. Commissioner Spies then directed Colonel Erasmus to prepare the investigative report. That investigative report made it to your office. What effect does A2 have on that sequence, if any?
It means the Jeff Weeks media query, because within it is an allegation of misconduct. When Spies he would not be able to appoint or instruct Erasmus to conduct an investigation. He would have had to take that query and give it to Behari. And Behari would then consider, in terms of A2, if you read A2, a request for allegations must be submitted to HOD CLS upon determination of a prima facie cause for HOD CLS. And that's convoluted. That's seriously convoluted. And I deal with that. But effectively, it is Behari who must now consider the evidentiary material of what at that point is still just a request to investigate. But you must take it to him to consider whether there is material that actually must now form the basis upon which an investigation must be conducted. You know, the collective agreement commissioner says an allegation of misconduct. You know, it does not even say that it's an allegation of misconduct in writing. It says an allegation of misconduct. In our circular in 2018, we insisted that the allegation must be in writing, even though the collective agreement does not go that far. The parties in the bargaining council recognize that you might have employees who might not be in a position to actually articulate an allegation in writing. Now, you have this situation that changes and says an HOD cannot investigate in his department, cannot conduct an investigation in his department. The HOD must go to another HOD, and that HOD must actually make a determination on whether indeed you are going to investigate.
I see practical difficulties with this. At what level should the allegations be for you to take them to the head of legal? It may be the barest of allegations, and then references made to a prima facie cause, who gets to the level of a prima facie cause? Will the HOD legal or will the head of legal then have to do an investigation herself to get to the level of a prima facie case? Or must she or he determine the existence of a prima facie case on the basis of the bare allegations without any investigation having been conducted? Unless I'm misreading it, it's confusing to me. It raises practical difficulties. In fact, most matters would not pass the level of a prima facie cause for an investigation to then be conducted. They would never pass because it would, in most cases, just be the barest of allegations.
And hence I addressed that, Chair, on page 318. What you have just indicated now is the same sense that I had. I'm saying upon Roman figure 2, upon determination of a prima facie cause, the memorandum is rather confusing in its articulation in this regard. There is no clarity on the following aspects which are pertinent to a determination of a prima facie cause. What is meant by upon determination? Who determines the prima facie? The request to investigate submitted to HODCLS, no clarity on who will conduct the investigation or whether the HODCLS is intended to approve that a line HOD conducts an investigation in his or her department, or that the HODSLS will conduct the investigation himself. Is the determination as made by whoever, because it's not clear, contingent on the investigation report, which is not clarified on who, on how same is to be conducted. I want to agree with you, and that's exactly what my thoughts were when I responded to this, to say it will create serious problems for the municipality. It's really impractical.
I'm very sorry. If the idea was for the head of legal to do the initial investigation that brings her or him to the level of a prima facie cause, that is all that she or he would ever be able to do within the municipality, because you say you handle thousands and thousands of matters. So would they still within legal be able to do the work that they exist for? It's I don't know, you know better. You are part of HR. Maybe you know that you sitting there, you'll be able to say, no. They have capacity. They could have been able to do all of that.
Impossible. I would not be able to do it. And I'm not the head of department. The legal department has to deal with everything in the municipality. There's issues of supply chain management. There's issues that concern bylaws, municipal courts. There's a whole lot of things that they have to deal with. And this HOD must oversee all of the issues. Now, for him to actually conduct investigations, and as you say, Chair, some allegations are just bare allegations. They are bare allegations, and some issues. Yesterday we talked about whistleblower issues. In most cases, a whistleblower will just give you that something is happening there, but they're not going to provide you with the evidentiary material. Now you have an investigator must go and conduct an investigation and get the evidentiary material. And it cannot be at the level of an HOD. The norm has always been you have the HOD of the department receives allegations of misconduct, causes the allegations to be investigated in his department by people who've got know-how of how the department actually functions and operates. Then those people are able to draw the information, craft a report, annex the detail or the evidence to their report. Then we can take it for determination, But this was just a bit, But I raised that, the issue that you've noted, Chair, besides the fact that the municipality has got standing investigations units, there are people appointed there who are paid by the municipality, And now you are simply saying they can't do their work unless the HOD CLS approves that they do the work.
So as matters existed prior to this, there was devolution of powers across the municipality.
There was what, Chair?
The work was spread out.
Yes.
The work was spread out across the municipalities. There would be an investigation there, all the way across by various people who would then produce the dockets or dossiers, and then eventually they would land at your desk.
Exactly, Chair. That's how it operated. And quite honestly, it was a seamless process. You have issues in the department, you investigate them. Once you've determined that indeed there is prima facie cause, we are the head of department, we are the head of department. You have a right to make a determination that, indeed this employee seems to have infringed or contravened rules.
That comes from a collection from all these focal points, and then everything comes from you. The legwork having been done.
Yes.
Now, the suggestion is for the head of legal to do the legwork. Because how else does he reach a determination of prima facie cause where there are bare allegations without that legwork having been done?
Effectively.
Impractical, it seems to me, unless the people who crafted this were to come and explain how they work.
And why I had to craft this response as a person who has got the technical know-how in terms of how discipline management is dealt with in the municipality. I'm raising these issues with the accounting officer to say, but your letter has got these practical problems. Besides the fact that it creates a mess of the process, as opposed to what the intention was. If the intention was genuine, and quite honestly, I want to maintain that this is because of one case. We've never had a problem. There's never been an issue until the Mkhwanazi case. There's never, ever in the municipality. We handled discipline. I go on and you will see in my memo, I even talk about a comparative analysis that I conducted that speaks to how we as Ekurhuleni, where if we were to benchmark us against the other metros in Gauteng, where we were in terms of discipline management as a municipality.
Mr. Nciza, that letter at 311, or that directive circular at 311, which tells you what the new regime is going to be, it says at page 312, the paragraph above A1, there's a paragraph there, and then it sets out what is intended to be achieved with this new regime. And it says to usher in expeditious, credible, consistent, and uniform management of discipline within the municipality. Had there been an issue on those aspects in the municipality, how discipline was applied, expeditiousness, had those issues been raised and discussed with the HOD and you at any point?
Madam Commissioner, there's always issues that are raised with discipline management in every institution. And this stems, the biggest issue that was ever raised that we've had to deal with as labor relations is age analysis. That has always been the biggest issue that we've ever raised. You have a disciplinary hearing. You constitute it, you appoint the committee, the first sitting, you go to the first sitting, you get a request for further particulars. You have to deal with the request for further particulars. Once you've submitted the further particulars, there are points in limine that are raised. Once you've dealt with the points in limine, there's a recusal application that is raised, and boom, 2 years down the line, the case is not complete. That is the biggest problem that we've ever faced. Age analysis. So when now mention is made of expeditious, one would think maybe the intention is to ensure that you shorten, the lifespan of dismally hearings. But it cannot be expeditious in relation to the constitution of a dismally hearing. Before the 2018 collective agreement, we had a 2010 collective agreement that said, if you do not institute discipline, after I've made the determination, my 12th April determination, if I do not then actually ensure that the dismally hearing commences after 3 months, I had to go and apply for condonation in terms of that collective agreement. And that was always an issue, not only on municipality, but in the sector as a whole. Because there's this problem, even after I've made a determination, you find that we delay, municipalities delay in instituting the actual case, in commencing the dismally hearing. So that, for me, expeditious must relate to that, that once you've got your investigation concluded, start the case as soon as possible. So there's never been an issue. We always start our cases within the 3 months period. Credible, I don't know about credible, because all our dismally hearings have been credible. The only way that you can determine the credibility of a dismally hearing, in my view, is that if indeed you conduct a dismally hearing and you dismiss an employee as a result of that dismally hearing, you then take the matter to arbitration and in terms of dispute resolution mechanisms. And then a commissioner says, you know what? The conduct of the employer was abhorrent here. You just had it in for this employee. Then it questions the credibility of your process. But that questioning of the credibility of the process will then arise out of an arbitration award that will be issued. That will talk to, you had it in for this employee, the evidence was shoddy, your processes were just malicious and all sorts of things. Then you can talk credibility, But I can assure this commission that for as long as I've been the divisional head employee relations in that municipality, we've never had questions about the credibility of our processes. I think when I read this, I went into, okay, credibility when you charge Mkhwanazi is not a credible process. Because I've never had questions even from, and remember, we submit reports on a quarterly basis to the oversight committee that deals with corporate services in the municipality. And we've never received any feedback from political leadership that says our processes are not credible. They will complain about how long it takes. That was the main issue.
I know Commissioner Balo is still asking. I just want to ask a quick question on the question of credibility. A finding of not guilty would not necessarily be an imputation on lack of credibility. Is that not so? On its own.
Yes. To answer that, Chair, I once had a nice debate with the member of the Mayoral Committee for Corporate Services around that, and I gave my own understanding of what discipline management is about. When, as an employer, you find an employee not guilty, you should be happy, because it then says that you've got a honest, credible employee in your service. Indeed, there were allegations against the employee that you brought as the employer, and you find that, no, an objective analysis of the situation says the employee is not guilty. To me, that says you've done your work, because discipline management, in my view, it should not be a punitive measure. It should be more of a corrective measure. And if indeed you find that, no, these allegations do not actually result in a dismissal, they do not result in a sanction, and then you should, as a manager, I'm happy, I'm fine, I'm fine, because I've done my part. And indeed, an objective person has said there is nothing to it. So it doesn't call into question the credibility of the process.
Can I just explain the base of my question, or the premise of my question is, in that paragraph, a reason is provided to justify these changes, right? So that we've got expeditious, credible, consistent, and uniform management of discipline. That's why now these changes. And my question was to seek to establish with you whether there had been a problem about these issues that now are purportedly being remedied with this new procedure. And your answer so far is there had never been these issues.
To give it straight, when I took over as divisional head in 2017, we had about, in our case roll, we had about 250 disciplinary cases. At the time of my dismissal, I had 51. We've managed discipline, not only in terms of managing the case roll, but also managing conduct and behavior in the institution. So honestly, these are good principles. Make no mistake, indeed, this is what is required, no problem. But it is not because there was a lack of. There was no lack of. In fact, we had improved.
Thank you. Thank you, Mr. Nciza.
Let us adjourn and resume at 11:22. Let's adjourn.